Hello and welcome to another pre-recorded session of the International Symposium on Digital Privacy and Social Media, being held in San Jose, California on the 1st of August 2022. My name is Katina and I'm the Executive Chair of the Symposium. I'd like to begin by acknowledging the main technical sponsor of our event, the IEEE Consumer Technology Society, for making this symposium possible. CTSOC realized that they required a transdisciplinary approach to addressing global pressing issues related to the design and development of consumer technologies, and have called for diverse stakeholders to come together to respond to digital privacy requirements and matters pertaining to social media in particular. I would also like to thank for their patronage, our gold patron, the IEEE Digital Privacy Initiative, and our silver patron, the Prototype Company led by Darren Calbreth. And of course, for their ongoing support, the IEEE Society on the Social Implications of Technologies Technical Committee on Socio-Technical Systems, led by Dr. Robert Abbas, and also the IEEE Santa Clara section and the CTSOC San Francisco Bay Area chapter. Today, we have with us Dr. David Kolevsky of the University of Wollongong. David completed his PhD in 2021 and is now continuing his practice in industry in supply chain management. David's PhD, titled Cloud Computing Data Breaches, Socio-Technical Implications, was supervised by Dr. Mark Freeman, Dr. Robert Abbas, and myself, and is a unique contribution to the literature. Today, David and I will be discussing data breaches in the cloud, and welcome to you, David.
Thank you for the invitation.
Can you tell us a bit about what your thesis was on?
Well, the thesis was quite a journey. So originally, I tried to investigate the privacy and security implications of cloud computing, and that quickly led me down the path of where cloud was going. And then also exploring the implications of that technology. It was apparent very early on, even within the literature, that a lot of issues were gaining traction, especially in the social, technical, as well as the environment. So regulatory and legal aspects of clouds. It was, and then it eventually led me to investigate 3 prominent cloud computing data breaches. I investigated the Sony PlayStation breach that occurred in 2011. I also investigated the 2014 eBay data breach and the 2016 Yahoo data breach. And that brought insight into the very large scale of end users that were also impacted, as well as the breadth of information that was disclosed. I also investigated the legal outcomes of those breaches within the US context. And it was very apparent that the legal sphere was underdeveloped at that particular time, and it's still going in its development cycle. One of the main contributions of the thesis was identifying that identity data was the most prominent issue facing end users, as well as looking at the regulatory aspect of storing end user data. Yeah.
A lot of people look at the cloud, right? And we can mention the top 3 or 4 players in the world, most of which have sprouted up out of Silicon Valley, which is where we're hosting the conference this coming Monday, US time. And General population doesn't tend to understand that a lot of the applications they're using are based in the cloud. Can you tell me how we might raise awareness? And how can, the everyday person that's using an everyday app, it could be social media, it could be otherwise, finds out where their actual data is being stored?
Yes, a lot of, if not all, or mostly all online services that end users subscribe to, as well as business users, they are predominantly stored on a cloud service. So regardless if you're an end user, online gaming individual, you are most probably using a cloud service. Facebook itself is using a cloud platform, and many other services out there are using cloud platforms. It's become so tightly integrated within our daily life that it's very difficult to distinguish whether you are using a cloud service or whether you're using a private proprietary service. I would say it's very difficult for an end user to actually become aware whether they're using a cloud service.
Do you think people care when they give away personal information, especially personally identifiable information, to platforms or to service providers or even to well-known brands on the online platform? Do you think they're cognizant of what they're doing, or they just want to get to the service as fast as possible?
I would say it's a multifaceted issue that we have going. I would say users want to subscribe to a service as quickly as possible, whether it's a financial service, whether it's a social media service, whether it's a gaming service, for instance. But then at the same time, culturally, the younger generation might not perceive their information to be valuable at the time of subscription. We are seeing a lot more younger generation users, whether children, teenagers, signing up to a cloud service such as Facebook without even knowing the repercussions of that subscription. But then at the same time, it's very difficult for a young individual to know the repercussions of using that service. So I would say users want to subscribe as quick as possible. They want to be in action. They want to be in the zone.
So, David, what we've seen of late is an increase in security breaches, and the size of the breaches being much greater than that which we were studying back in 2014-15. Why is that happening?
I think it's a natural progression of the amount of end users that are subscribing to these services. And it's only natural for the breach to comprise of more end users as more users sign up. For example, the 2011 Sony breach impacted 70 million end users, whereas the 2016 Yahoo breach impacted over 1 billion users. So you can see the magnitude of the scale, but then also the amount of breaches that are occurring at any single given time.
So do end users, David, actually know how soon after a data breach has occurred that actually their personal information has been compromised? Or what have you learned from looking at these cases that you've been studying?
So that depends on the jurisdiction that the corporation is located. The US has a various state-based notification system, whereas in the EU is very centralized according to the general data protection regulation. So you have a very scattered notification systems that where one might require 36 to 48 hour notice, where other jurisdictions might require within 24 hours. So for a corporation, or I should say a cloud customer or a cloud provider, they would have to adhere to several notification systems if they're operating in more than one jurisdiction. So it's a very complex notification system that's currently being applied.
We've discussed previously the lag between notifying the end user and the breach. Sometimes it's like 2 weeks, and you're thinking like 2 weeks, a few days of the system down, and then a few days after that and a bit more time. And as you say, in different parts, information and privacy commissioners may be notified or may not, depending in, like in the Australian context, they have to have a particular revenue turnover to be held accountable to the data breach notification rules. It's fascinating. You mentioned personally identifiable data. Can you give us examples, like specific examples of attributes that might have been taken by hackers?
That ranges from usernames, first name, last name, addresses, phone numbers, email addresses, in more severe cases, geolocation data, financial data, so credit card data, debit card data, bank account details, security questions and answers. But we're also seeing a more severe type of information, such as biometric data, that is starting to get disclosed by these breaches. And one of the significant issues of this type of data being disclosed is that you simply cannot change your biometric facial recognition or your iris. So once again, you can see the natural progression of the data sensitivity, where once you could change your username, you could change your password, when now it's becoming more and more difficult to change these attributes that are unique.
It has been really embarrassing for many of the agencies in the US, government agencies, in fact, to have that data compromised. And tell me what you think that value is worth.
I personally believe end user data is invaluable. That's your name, that's your address, that's your phone number, that's your identity that someone can not only disclose, but can also use against you. They can file for credit card applications. They can defraud you to the point where they know all this information about you. And the more sinister thing is that these types of data are spread across multiple online services. So not only hackers can use this type of data, but they can aggregate this data to perform a social profile.
We've read a lot about hackers who have later changed their ways after being convicted by the Federal Bureau of Investigation, for example, the FBI in the US, and they tell all to the FBI so they can ensure that they don't go to, incarceration. They're not incarcerated. And we see these amazing stories about the dark web and how millions of credit card details and address information can be sold for pittance sometimes. And you think, what is the value of putting all of this in the dark web if it's only going to be sold for like a couple of cents per record, although they have many records in the millions, so it's all commensurate. But it's fascinating how well trained they are to evade conviction and evade being caught. We're talking about big companies here with billions of users like Facebook that have had data breach after data breach, especially around 2017, 18. And we're not just talking here about Cambridge Analytica scandals. It's far, far beyond that. And you'd have to think to yourself, well, how come we don't hear about these breaches enough as consumers? They happen, the Target hack and a whole bunch of Equifax, massive data breaches affecting such a large population. It's almost like it gets into the news, it teeters a bit, and then it leaves, the audience. But in the courts, the slugfest continues for years and years and years. Can you give us an example of one case, perhaps, and how long it's taken in the court to resolve, if at all?
Very ironic that you asked this question. It's only this week that the 2016 Uber data breach finally got some form of outcome within the US court systems. And that was a 6-year process from end users knowing that the data got disclosed, applying for class action lawsuits, going down that tedious process, and then finally getting some form of outcome, which might be compensation, identity monitoring for 12 months. So you can see that corporations, that they're dragging out the court process. So not only do they try and break the class action lawsuits, but then try to extend it out as much as possible to delay the outcome.
Once again, you position it very well. All of these users in different states in the US, all under different rulings, and an organization going through the court process, trying to be held accountable for what has happened. Tell us how people assemble to do things like class action lawsuits, and then tell us what the courts have judged based on the court cases.
Well, the 2011 Sony data breach, that was a 3-year court system, 3-year court process, and that resulted in end users from multiple states forming their own class actions, but then further progressing, they try and join these class actions together, and that was also witnessed in the 2016 Yahoo data breach, where we saw numerous class actions, and then forming a bigger class action within the state of California, which is the most progressive in terms of end user data protection. So you can see end users from states that have less end user data protection and trying to move to a state where it's more geared towards data protection. So you can clearly see that occurring.
And what have the judges ruled on occasion? I mean, should we expect judges to say, yep, all these consumers, millions of them, hundreds of millions, they should be remunerated for the loss of their data? Or do we hear something else? Like, what is the most common response by a judge after this grueling long court process? Has it been worth it, David, to have gone through this process and those class action lawsuits, people's, pro bono time with the legal side? What have the judges said?
One of the most fascinating things that these class action lawsuits do show us is the notion of non-physical injury. And that has been witnessed across so many different class actions. It becomes quite a standard process of denying a lot of class action lawsuits based on that motion. So you can clearly see that there is a push to emphasize that injury can occur, but it's more about the fact that proving that, identifying that the data that has been disclosed can cause injury in the future. And they're predominantly based in the fact that the data may be misused at a later stage. There has been several class actions where they have successfully proved that, but at the same time, it's a very very precarious circumstance.
So you're pretty much saying that the consumer's stuffed.
Basically, yes.
In a way. I mean, you can't prove the injury, you can't prove the direct, issues playing out. So hey, your data is really worth nothing, even though it was a biometric. But I guess I concur with you that those class action lawsuits are raising a lot of awareness, and at least providing some pressure on both the business unit and the cloud providers to change. Although, someone might say security breaches will be a perpetual issue so long as we have digital environments. Do you concur with that? Do you think it'll be ongoing?
I definitely believe it will be ongoing. As more and more services become integrated into the cloud, and more users every day subscribing to so many various cloud services, it will become, without a doubt, that more data breaches will occur, or data breaches in general, whether they like to say that it's a cloud service or not. But then the severity of the breach will become more and more intense. So it's not only identifiable information, but also geolocation data, financial data, coupled with sensitive information, healthcare records, your medical records. These all coupled together, which is going to cause a lot more strain on the court system, because as more and more users go to the courts, because their data protection regulation is not at the level that is required, they're going to go to the court system to seek a compensation or to seek an outcome.
David, tell us about what service level agreements are.
Service level agreements are a contractual agreement between one user of the system and another user of the system. There are service level agreements, for example, between a cloud customer, e.g. Sony, that might be using a cloud provider, such as Amazon Web Services. So they might have a business service level agreement that not only has attributes such as uptime, downtime, bandwidth, storage, computation requirements, but then at the same time, service metrics such as data availability, security, and privacy and trust requirements are tightly integrated within the service level agreement. Now that's between a business and a business, but then you have service level agreements between the end user of the system and the cloud customer or provider. And this is where the agreement is not visible. It might be complex. It might utilize language that is not geared towards the end user. And this is what we're seeing at the moment. You subscribe to a service, the language that's used on that agreement is complex. And then, like at certain times, even an individual with a law background might have difficulty interpreting the agreement. So not only we have a business to business SLA, but we also have a business to consumer SLA. And this is where the problem arises, because a service level agreement is constructed by the business, and end users have very little say in what they can have. So it's a very one-sided agreement. So the terms are set by the business or by the provider, and basically, if you want to use that service, you have to agree.
So already from what I'm hearing from you, SLAs are there to almost be self-serving in some way, although they're very important contracts. But consumers always seem to lose out in this dynamic. And then there's a blame game perhaps between the service provider and business that we generally never hear about in the media, because they're going, that's their fault. Not my fault, it's their fault, right?
Yes.
And people are caught in the crossfire, and there are damages. Like you breach your SLA, you don't live up to it. There are penalties, right? As you just mentioned. But the poor old customer always seems to be losing out. And I do wonder how we may recover that power imbalance. Like in the outcomes of your thesis, what were some of the findings you had? What were some of the recommendations you had?
My recommendations were based from a very low level individual end user perspective, going all the way to a government level, environment level perspective. So I'll start from an end user perspective. So one of my first recommendations based on the outcomes of my research was that the end user needs to have a privacy or a privacy advocate that serves them at the time of need. At the business level, incorporating certain individuals within the business that understand what cloud service they're using from a technical perspective. So such as incorporating a chief information security officer, having the appropriate training when the business adopts the cloud service, but then also the ongoing process. And then finally, the most important aspect, I would say from a government perspective, is regulation, so cloud regulation. And the emphasis that a federal data breach notification system that oversees the state's responsibilities. But then also seeing data protection as not only a mechanism that end users can benefit, but also the sustainability of the cloud service from growing. So businesses shouldn't see regulation as a negative per se. I would rather emphasize that they should work together with government in a very collaborative approach and saying, well, these are the positives of the regulation, but these are the negatives. This is what we should work towards to. But this process shouldn't be once-off data protection mechanism. It should be ongoing. As a cloud system enhances, as it grows, as it migrates from stage to stage, at the same time, regulation should adopt to that service. So recommendation is basically a socio-technical recommendation, is the end user knowing where the data is located, having someone there, having someone knowledgeable to represent them when there is a data breach. But then also from a business perspective, having someone or having a group within an organization that works together with end users and government. And then finally, as I said, a more environmental perspective, regulating the cloud, regulating the way that services are used internally within our country or externally from multi-jurisdiction.
David, I've asked this question of all our interviewees. It's the last question that I always ask. If you had a single message for Silicon Valley, what would it be?
Embrace data protection regimes. Embrace regulation. Corporations, cloud customers, and cloud providers together holistically should embrace regulation for the sustainability of the service. Where we once thought that regulating a particular industry stops the innovation process, I believe otherwise. I believe for the innovation to be sustainable in the long term and for new and emerging technology to evolve, regulation must be implemented together with the technology innovation.
Well, that's a fantastic message to end this interview with. And I want to remind everyone, they can read your extensive work over 7 years on cloud computing data breaches in the IEEE Explore corpus. You have many articles and many forthcoming. And for that, I really celebrate the outcomes of your research. Spent over many, many years reading hundreds, if not thousands, I would say, of news items, trade journals, and legal cases. If you've enjoyed listening to this presentation, a pre-record for the International Symposium on Digital Privacy in Social Media, consider registering for the 1st of August 2022. We are allowing both in-person in San Jose registration and also virtual registration at this address. If you'd like to listen to this interview in a few days' time, or traverse any of the other pre-records, up to about 20 or so, please visit the attend.ieee.org website as viewed here on the webpage, and also reach out to the Consumer Technology Society, Digital Privacy Initiatives, Society on the Social Implications of Technology, and IEEE Future Directions Committee. We've listened to a full-length Q&A interview with Dr. David Kolevsky of the University of Wollongong. We congratulate him on the completion of his thesis last year and wish him all the best in his practice. Thanks so much again, David, for spending so much time with us today talking about data breaches in the cloud.
Thank you, Katina.